Alex here with a legal nuts and bolts video on assuming the other side's argument, or I guess in the sense of a high conflict child custody case, more specifically, assuming your ex's argument. Like many of the legal nuts and bolts videos, this is something that probably most of my viewers can relate to that are in high conflict child custody cases. And the only reason I put it under this category is because it really goes beyond a family court. But I still want to go ahead and use examples consistent with family court because that's where most of my viewers are um, coming from. So this definitely happened in my case a few times, and it does confuse the court, and it does also kind of catch you off guard when it happens to you. So I'm just going to warn people not to do this particular thing that I used to do that I'm sure many parents do. Oftentimes, these cases involve huge arguments that are not in court. They are over the phone, voicemails, text messages, emails, family wizard messages, all those other apps. Huge arguments that are not in front of the court will occur, and eventually something's going to get filed. And what's going to happen, what happened in my case, what happened with me, is you're just going to assume that whatever it was your ex's position, whatever position your ex was taking in those messages or voicemails or whatever, is the position they're going to take in court. And that's not necessarily the case. And I think part of it is because they have an attorney and their attorney might tell them this is nonsense, we're going in another direction. And then another part of it is just plain to confuse you and the court. It's a strategy that apparently is very common. And what I mean by that, like I mentioned to you guys, has happened in my own case, is I would file a motion and then I would include all of the things that my ex was saying in the motion, just assuming that that was going to be her position. And then an opposition would get filed and they'd go in a completely different direction. And it just confuses the judge because they're like, what? This person is saying that this is the argument. His ex filed an opposition. They're not even talking about that. So it creates all this extra information, all this confusion. And then it's unsettling to you as a non-attorney who's just assuming that whatever it was you were arguing about in all those documents is the same thing you're going to argue about in court. And then you get to court and you completely knocked off your feet because they have a completely different argument that you didn't expect. So the point of this video is when you go to court to argue your own position. If the other side is going to argue the things that they were arguing with, over email and phone, let them do that in their opposition. If they're not, then you deal with the opposition that you get. It's much less confusing for the court when you argue your position only because the other side is going to get their opportunity to argue theirs. It's like I said, guys, it's a common mistake, very common mistake for you to just assume that all the things that you were bickering over are the same things that are going to be in front of the judge. But from what I have seen in my own case and in other people's cases multiple times, it's very common for the other side, once you're actually in the courtroom, to take a completely different direction. So if you argue your own position only and you wait to see what they have to say, it will be less confusing for the court. There will be less information for the court to consider because now all of that extra information that you would have put in there if you didn't know what you were doing, you didn't put in there because you've seen this video. So easier for the judge, less confusing for everyone involved. It's going to be less unsettling for you because then you can deal with, on reply, the things that they actually decided to put in their opposition. This happened in my case, guys. I already mentioned it earlier in the video. I will mention that I eventually figured this out, and then later on, if you watch my docket series on the high conflict child custody case that I went through, you'll see towards years 4, 5, 6, 7, I started to argue more clearly and concisely to the court. I started to understand this. If you look towards the beginning of my filings, you may see where I kind of led the court in various directions that I just assumed my ex was going to lead the court into, that they actually didn't do. And I think during some of the videos I even talk about this, how frustrating it is for that to happen. The most extreme example of a mistake that I've seen somebody make in this sort of line of thinking, and I didn't do this, but I have seen at least 2 other people do this, maybe even 3 or 4. Just off the top of my head, I can think of 2 other examples. Is the one parent goes to family court and files a motion for their ex, which is extremely confusing to the judge when their ex then files an opposition to it. I've seen people do this. Do not do it. It's really, really weird. And then if the other side files an opposition to it and they have an attorney, they might get attorney fees and financially cripple you. So I think one of the cases was they were trying to change the visitation schedule for their ex, and then the other situation was child support. So basically, they felt bad for their ex. They were paying too much child support, and they filed a motion to modify child support for their ex to be nice, to be the nice person and do it for them, since they were afraid of the court system or they were too busy or whatever. And then I think the other one was visitation schedule. Their ex had to work or got a new job, or their shift changed, something like that. They felt bad for their ex, so they filed a motion to modify the visitation timeshare. And then in both of those cases, their ex, rather than say thank you for taking care of this for me, filed an opposition. So could you imagine what that looks like to the judge? And then imagine how it feels, because you're like, what the heck? I wouldn't have even filed this if I thought they didn't want this. And now what? Now there's briefing in front of the court, and now you have a reply coming up. It's just a headache. If your ex needs to modify something, they need to file, and then you can file a non-opposition if that's what you want to do. I've seen enough people do this that I decided it's time to do a video on this, because it's definitely something that apparently non-attorneys accidentally do because they just don't know any better and they're just trying to be nice. So yeah, the whole gist of this video, guys, is argue your own position only. Wait and see what the other side argues. Let them argue what they want to argue in their opposition. Don't just assume all of the positions that they're going to take. Yeah, of course, keep them in the back of your mind for when you get to a hearing or for when you file your reply. Yeah, keep them in the back of your mind and wait and see. And then once you see what the other side's position is, then you can go ahead and, respond accordingly. But don't just assume and lead the court down various different paths without knowing that that's actually what's the path that the court's going to have to go down to. I hope that this video is useful to my viewers. I definitely know that it's a mistake I made, and it definitely will help you if you don't make that same mistake, especially because you're going to feel like you've been backstabbed. Most of the people who filed motions to be really nice to their ex only to get an opposition felt like they were backstabbed. In fact, if you go and watch the video Exploiting Good Faith, I think kind of the gist behind what that is discussed in the video Exploiting Good Faith. All right, guys, if you have any questions, as I mentioned earlier, feel free to post them down in the comments below, and I will see you guys next time.